Hello there, everybody. Hello, hello, hello. Hope everybody's well. Greetings, salutations, whatever nonsense I'm going to talk about. I wanted to greet everybody who's here, like I like to do. And I appreciate everybody here. Not legal advice. Please like, subscribe, share, comment, whatever else applies. Share the word, spread the word. Thank you for doing that, by the way. And I want to say a quick hello to those I see out there. Again, my most ardent fan, and I really appreciate his patronage or her patronage. It's either Mr. or Mrs. Never indicate their gender, but Mr. or Mrs. StreamYard, thank you for being here. John, Toe Cramp, Gator Boy, Born Free Films, Barbara, Renee, GTII, Millie Maker, Steve, Mike, Bogey One. That sounds like a golf name, by the way. The One, and Wickedums, and everybody else who's here or comes in here. Greetings, La Liga. That's soccer league, right? In Mexico, I think. Big JR, McGruff, Ben Palmer. I could do this all day, but thank you very much for all yous who come out here. So as I promised, I'm continuing the idea of updating you all as we go. So there's nobody in the dark, as much as there's nobody in the dark, because there are people in the dark, even myself, but that's what we're going to do. And I will go through some stuff and it'll make sense as we go on. Before we start, of course, why did the vegetable thief wet his pants? Because he took a leak. To the guy who stole my antidepressants, I hope you're happy. To the person who stole my selfie stick, you need to take a long look at yourself. And last but not least, although there will be ones at the end, as I've indicated before, and hopefully they're the best ones, if there is such a thing, the best kind of thief has nerves of steel. Anyway, so what I kind of wanted to do was go through some things here today that I saw this week. So this is this week's stuff, and a few things. So the first thing I'm going to talk about is I saw yesterday Alpine Securities and the NSCC, that action, which basically the DTCCCCCC got rid of Alpine, but then there was a appeal and then a stay and some briefing that has to be done. And yesterday, or at least it's dated September 24th. Yeah, that would be yesterday. There was an order filed extending the time. So both parties agreed to extend the time. The SEC and the attorneys for Alpine agreed to extend the time to give them more time to brief because, you know, of course, Alpine hasn't had enough time to file briefs or do anything in this matter. So why not SEC give them more time because they're such fine citizens, as you've declared. Why not give them more time to see what they could do to muck up the matter? Another example, again, of a completely regulators just have no idea what's going on. And, you know, a lot of people thought since Atkins was coming in that he wouldn't be as big a stooge as Gensler, and he's as big a stooge, if not a bigger stooge than what preceded him. And I saw yesterday, the day before, there was a matter in a firm that his client had been charged with misconduct, and they worked out some arrangement. And surprisingly enough, the charges against his former client were dropped also. I'm sure that was just mere coincidence. I'm sure. And, you know, I kind of reference, sometimes I post on X saying that something's happened in the GTII case. And I reference that a lot of times I will talk about something and then lo and behold, there'll be some action that happens thereafter. And I just assume that's just coincidence also. So like today, we're talking today, and I know the Receivers Council knows that I'm speaking today. I know that because I communicated with them, and I'm going to talk about that a little bit. So it'll be interesting to see if we see some action taken either today or tomorrow, and I will certainly apprise you if there is. I'm annoyed about the DTCC and the SEC because they just just screwing around more, not doing anything. I don't think they're protecting retail in any respect. If you recall, I bitched about the new proposed 6-month reporting period, and to the extent that you can comment on that, please do so. If anybody thinks it's helpful for retails, I think you're out of your keister. That's your butt. I think it's out of you're incorrect. Let's just say that. And those who agree with me should write to and communicate directly to the SEC and oppose the change from quarterly reporting to 6-month reporting. I think it's ridiculous. Again, how many times can I say it's ridiculous? Another thing I want to just briefly touch upon, I had it somewhere, was I saw a comment or some kind of tweet by Forrester, and I had mentioned a tweet prior where he was indicating that for some reason or at least the impression was that the receiver was not communicating with him anymore. And then I saw one, either it was yesterday or the day before, I don't remember which one, where it was more discussing that still had not received communication. And again, based upon the first one, it sounds like we're now weeks of lack of communication. And he indicated, I think in the last one, that there was some reference to, he had brought up the issue of compensation. And after that, the receiver went dark, basically. It's my own interpretation. And of course, starting a couple months ago, maybe more, I brought up the issue of the double billing, the report should be prepared by the receiver and instead is being prepared by the receiver's counsel. And then on top of that, I then started bitching about, the 10%, about we didn't know about the number of shares that might be available. And it's 10% of 180 million shares, 18 million shares. Should that be the deal? And apparently in Forster's communication or prior communication or his counsel's communication, when they questioned the receiver's compensation, Forster, by his ex tweet, suggested that was kind of spurred the receiver into not responding. And I don't know if that's the case, but it wouldn't shock me under all the circumstances if the receiver wasn't disturbed by that, and if he wasn't looking out primarily for his own best interest. Now, in Nevada, even though I'm not a Nevada lawyer, this is not legal advice, of course, but I believe in a lot of states it's this way, that the receiver's compensation has to be overall reasonable, notwithstanding whatever the deal is. It's got to be reasonable, and I don't think it's reasonable on the moment in size and in terms of, and I mentioned this before, his shares. How can he get rid of his shares? Should he have priority? Does he have to wait? None of that's referenced in the order, and it all should be. And I think it's going to be addressed. People push about moving forward. I've seen all kinds of references to getting rid of the receiver or all that stuff. I think there's going to be an opportunity in the next court appearance when the compensation is sought by anybody or a deal is put up for shareholders to comment, and I'm certainly going to file a brief, and perhaps others will file briefs to the extent that they think they're relevant and they want to state their opinion. So I think it's going to come out. I think the concern amongst a lot of people is if you push on getting rid of the receiver, that could be used by the bad guys to basically throw the company into bankruptcy. So they are concerned that if you push too much on the receiver, that's the result. My view is, I understand that, and I have tried to be direct about what I think's important. I certainly don't want the shareholders to be penalized. I just want the receiver to do what he's supposed to do and do it in the transparent way. And again, the issue to this point in time is transparency. I understand if the receiver is pissed that he was expecting some level of compensation, and now that's being pushed back upon. So I'm fine if he gets reasonable compensation. I'm not against that. But I'm not fine if he's trying to shit can the other deal to get another deal in which he'll get his full 18 million shares or something and then be gone. And my concern is by not communicating, if that's true, and you'll see I asked that question later on, but if by not communicating, they think that they're going to get the AIversity guys just bail, and then they could put in their own deal, and their own deal, they wouldn't contest the share ownership, even though it goes in front of the court, if you could argue that the parties will have be more persuasive than the non-parties. And so that's my concern, is that the quiet period is an attempt to get Forster's group to bail, and then Strickland can put another group in that he has more influence on and get the compensation that he wants to get, which I don't think would be in the best interest of shareholders in terms of the compensation. I don't know who the partner would be. But that's my concern. So the lack of communication, that's where that leads to me, and that's why I am concerned about that. So that's why I brought it up. Now, before I get into some of the communication that I wanted to discuss, I became aware of, and I had forgotten about it, a whistleblower complaint that was filed in GTII in April of 2024, and it targeted GTII, Reichman, the directors and officers. It accused them, and this is before, obviously the receivers reports and the detailed, the precise details that came forward. The allegations were of looting, insider trading, stock manipulation, etc. Those were the kind of the general allegations. I'm looking at my notes now. That the question, I guess they asked a question whether the target's been made aware of it, GTII, and yes, they were made aware of it. This is like dozens of times. It involves the stock of GTII. And like some of the allegations are suppressing information about downlisting, looting, misappropriation of cash, share distribution without compensation, distribution of shares for no value in insider foundations in 2023, lying about release dates and contents of the 10K. Documents included 10K and numerous emails. I remember, by the way, is when I tried to communicate with GTII and their counsel, they were not being, I would say, forthright in what they were going to do. So that kind of is consistent with what that allegation is. And I had plenty of attempted contacts. So it's interesting to see. And then it says, where did you get the information? The information received directly from GTII, because that was response, or from counsel, apparently, or from people who had unfavorable contacts with GTII. And fraud and looting and non-disclosure are obvious from a cursory review of the financials. And that was submitted apparently April of 2024. And that was a whistleblower complaint. I have no idea what happened to it, but I thought it was interesting just to bring that to your attention. That's way before the receiver's detail, and the allegations that seemingly were made in that whistleblower complaint turned out to be 100% accurate. So I just found that was interesting. So wanted to bring that to your attention also. And so now I'm looking at an email I sent. So I'm going to go through some of the emails, and then we're going to bring it up to date, and then it'll make sense as we get to the end. So this is an email dated September 8th, 2025. It's from me to Mr. Strickland. As you know, I've previously asked for the halt of any trading of GTII stock. As you and your representatives, I believe, are reluctant to disclose non-public information because some might be still trading, I again urge you to seek the cessation of all trading in the U.S. and make a request in Canada. After the trading is stopped or virtually stopped, there should be no reason to hold back any information. Thank you for your consideration, Richard. So I sent that September 8th. I'd asked for it before. I've heard nothing back, and I've not seen in any report any attempts to undertake that in any respect. And again, even if they're not successful in being able to stop trading everywhere, if basically they can, then, and there's, very few shares, if there's, tens or hundreds of shares trading, then there's no reason not to be fully transparent, because there's no reason not to disclose and make everything public. And I don't understand the issue about not making everything public. I think everything should be being made public anyway. But I have instructed them and asked them to do this, and as far as I know, they haven't. I haven't received any information to the contrary. And, that's the way it goes. Wednesday, September 17th. And, so I bitch a lot about on these live streams, and I'm constantly sending communications. This is going on. I don't tell you about all the communications, but I'm constantly doing this. So September 17th, I'm sending one to the attorneys for the receiver, and it's short and sweet. Hello, any further depots scheduled? And number two, status of audit. So those are two things. And, any further depots. So we had the Frank B depots or depositions. That's what it stands for. Depositions are questioning under oath before a court reporter with the attorneys involved in asking questions. So I'm asking, have you scheduled any further depositions? Because I hadn't seen any as of that point in time. I don't remember if they well, it's further, so they must have done Frank B as of that point in time. Status of the audit is self-evident. Where's the audit? When is it going to be done? How could you be making deals without the audit? And there's going to be a kind of a response to that at the end when I get there. But that's all I'm asking. For the depots, status of audit. All right. I didn't hear anything back, by the way. Yeah, most of these, by the way, this is just the honest truth. Most I don't hear anything back. So I'm just making a record here. I'm asking questions, and they can or cannot respond. I think they're all relevant questions. And here we go. So I send out the next day, the 18th, another communication to the attorneys to the receiver. And this is how it goes. I'm just reading this verbatim, by the way. Other than attempting to block the disputed shareholders from keeping any shares, don't you think that letting them keep any of the shares without knowing what is in the completed audit is imprudent? That's a question. Without the completed audit, and then in parentheses, and in light of the content of the receiver's reports, it would be premature to do anything other than oppose the retention. Now, there I'm referring to the shares. Thanks. Didn't hear a response to that, by the way. And just the point is, I don't know how you could be making deals, transactions, distributing shares other than a zero giveaway and receiving everything back if you don't see the audit. And their example is, what happens if you think somebody stole 100 million shares and they stole 200 million shares and you're making a deal on the wrong terms? So I don't see it. And if you know the terms of the audit, then why not disclose them? If you're so confident in terms of the audit, if the audit is done, then why not disclose it? Because otherwise, I don't know how you could have any certainty as to the audit being or the numbers being accurate. It doesn't make quite sense to me there. Monday, September 22nd, me again, and by the way, still no response. And I'm just giving this as an example of a day in the life and the questions asked and the responses or lack thereof. Hello, I'm happy to. The purpose of this, what I'm doing here is, I'm trying to be fair, honestly. So if they have like a point to make, I want them to tell me so I can communicate that, because maybe it makes sense and maybe I'm out of my freaking mind, or maybe there's other positions that make more sense. So I am literally asking for their input, and I've asked for it many times. I couldn't tell you why they don't provide it. Pure speculation on my part, but they haven't. To a large part, they haven't responded. Period. To a large part. So this is September 22nd. Me to the attorneys for the receiver. Hello. Number one, I'm happy to speak with you as to any future motions. It says notions. My mistake. Motions seeking to compromise claims so that I can at least cogently communicate your position, even if and especially if I disagree. So I'm basically saying, if you're going to be doing stuff and you want to kind of give me a heads up as to why you're doing it, so I at least understand it, so I can communicate it, even if I disagree, I'm happy to do that. And no response, by the way. The second one, in more than one tweet, I've seen Forster indicate the receiver is not being responsive. Can you respond to that suggestion? Thank you. That was on the 22nd. Of course, I didn't get a response, which is kind of funny because I'm saying that Forster is saying you're not being responsive and they haven't been responsive. You could draw your own conclusion, and I haven't heard anything back. So you can kind of see I'm trying. I'm as best I can. I'm trying to be fair. And then on the 24th, and this is a little more detailed, and this kind of And I get a response to this one. So this is on September 24th. This is again to the same counsel, I think Strickland's counsel, who's copied on it. The continuing failure to keep everyone, and this is from me, the continuing failure to keep everyone in the dark is not appreciated. I expect that some shareholders will be getting together to attempt the removal of the receiver and perhaps the return of any compensation. And again, I'm not calling for the removal of the receiver. I'm calling for the receiver to do his job correctly and to be transparent. But I have, because I see it constantly, I do see other shareholders calling for that. And again, the caveat is if you get rid of them, are you cutting off your nose to spite your face? Should you be more kind of pulling them in and controlling them, as opposed to getting rid of them because you don't want to give the bad guys the opportunity? And again, I've stated before, the bad guys have gotten like the benefit of this whole deal. I would have come down much harder on them than the receiver did. So any claims by the bad guys that the receiver should get tossed because he hasn't been fair to them is nonsense, utter nonsense, and completely unrelated to what I'm saying. But there is a call by some shareholders to get rid of him. I'm not calling for that. I'm calling for him to do his job and be transparent about it. So I'm going to continue on. Wouldn't it be better to make everything public and not keep retail in the dark? Have you taken any action to stop Gtii from trading in light of my multiple requests? Any information about the audit? How can you make any deal without a final audit? Wouldn't that be premature? Why has the receiver stopped reporting at all? Why has the receiver stopped posting on X? Forster indicated on X today that you have stopped communicating with him ever since he raised the receiver's compensation as an issue. Do you dispute that? What is the receiver doing to close this transaction or any transaction? What deals were negotiated to raise claims that were filed? I will be discussing all the above in an upcoming live stream. As I requested a day or two ago, if you want to provide me your position on any or all of the above, please do so and get me a reply of any kind by 3:45 p.m. Pacific today. Thank you for your attention to this matter, Richard. So that's me. Send it on Wednesday at 9:55 a.m. And again, I just gave you an example of my communication. I've asked, probably dozens of times with any kind of response. And, I'm sure there's a reason that they will assert for no response, but that's just the truth. So here it's about 10 o'clock. So I gave him basically 6 hours to respond to all the questions I asserted. Now, I've asked these questions before, most of them, so these aren't new. So they don't require a lot of research and analysis, but I still gave him 6 hours to respond. And thankfully, I have to be honest, and that before 3:45, at 3:38 p.m., Mr. Siciliano did respond. So I have to give him credit for responding in a timely fashion. Now, I didn't think his, let me call it a reply. He replied. I don't think it was responsive per se, but at least he replied, and he replied in a timely fashion, and I have to give him credit for that. So I appreciate that. And let me read his response to my last correspondence. Thank you for your communication. One day we can discuss your experiences with what occurs when a company voluntarily delists and what is required to eventually get it retrading. Maybe our experiences are widely different, but it is certainly possible and or likely that it will never trade again once removed. There probably is no right answer, but if there is a 30% chance that delisting was permanent, would that be worth it? That's hypothetical, but that's the concern. Now, I have no idea what this is responding to. Honestly, I have no idea. This is complete I don't know. When he's referring to voluntarily delisting, GTI did not voluntarily delist. It was delisted. So I have no idea. Really, I have. When I read it, and I've read it over a couple of times, I had no idea what he's talking about here. The 30% chance, I think what he's trying to communicating, and maybe I'm wrong, but he thinks it's a 70-30 chance in favor. And again, I don't know. So this is pure speculation. But he's saying that if you get delisted, perhaps there's a 30% chance that the delisting will be permanent. If I use that logic, then I think he's saying that there's a 70% chance that the delisting won't be permanent. And I presume he's talking about GTII, but I don't know, but I presume, because apparently it's in response to my prior email. I'm going to continue on. And again, if you have all ideas that are different than mine, then please, maybe my analysis and understanding it just doesn't make sense to me. Next paragraph. There are no grounds to remove the receiver, but I appreciate that some people have instilled that idea in shareholders and likewise suggested they should sue the receiver. Given the realities, I think the purpose behind the statements is intimidation. As I have welcomed anyone, if they believe there is cause, I'm happy to address it with the court. So, so let's go through it. So there's no grounds to remove the receiver. I don't know if that's true or not. I have complaints about the receiver. I'm not seeking his removal, but I know others have clamored about it. So there may be grounds. I don't know. Maybe we saw the audit and the other work product, the bills, the invoices, all that stuff. It might be easier to decide one way or the other, but I don't know. But I appreciate some people have instilled that idea in shareholders and likewise suggested they should sue the receiver. I don't know who has called for, and I've seen the calls for him to be removed. And I've seen many shareholders were pissed and want to go after the receiver. So I don't know if he's referring to individual shareholders or some person. I don't know if he's referring to me. I certainly have not called for the removal. I've called for, again, the receiver to do his job and be transparent. I have no interest in suing the receiver, and there's a business judgment rule. It makes it hard. It's in Nevada. But, if his compensation is not appropriate, there's no reason not to object to his compensation before it's provided. If you think otherwise, then you should support him. But I don't know who he's referring to because that doesn't name names, which kind of creates more ambiguity. I think the purpose behind the statement is intimidation. I don't know what the people are clamoring about, if they're trying to intimidate the receiver. I just think they're trying to get the receiver to do his job. And I think somebody claiming that that they're trying to intimidate the receiver is nonsense, absolute nonsense, and kind of belittling of shareholders, and annoying and piss me off, honestly, as I read it now. Because complete nonsense. I think shareholders are interested in the receiver doing their job, and for doing it in a reasonable manner, with a reasonable price, with reasonable transparency. And I don't think he's done that to this point in time. Or else, I wouldn't be clamoring for, all this information. He had an opportunity to provide that information. I don't know why he hasn't. Doesn't have to do a 55-page report. He could do a 2-page report. Doesn't have to spend 50 grand on the report. He could spend 2 grand on the report. It's not that complicated. Next paragraph. Not everything can or should be made public. I agree with that. As we explained, and contrary to your assumptions, I don't know what assumptions he's referring to, the receiver's position has been to keep a tight ship as to not jeopardize the integrity of his investigation, regulatory actions, and litigation strategies. So I guess they're saying that they're trying to justify the lack of transparency, that they have some basis to do that. I'm not particularly impressed that they have some rationale for not being transparent. That doesn't make me feel any better. That doesn't make me think that their actions are any more justified, although I'm not complaining about anything in particular. I'm just responding to this kind of vague response that I can't tell if it's directed at me or not directed at me. I can't tell who it's directed at because I didn't use people. And I asked, by the way, you will see. And I agree, by the way, not everything should be public. There are likewise competing interests looking to advance their own purposes. So is that admitting that the receivers has his own purposes, that the receivers counsel has their own purposes, that retail shareholders have their own purposes? I guess, is that admission that there's a conflict of interest? I don't know. Competing interests. I guess that's possible, but I know that certain people have fiduciary duties to shareholders. And notwithstanding whatever their competing interests would be, I really don't understand that, because I think the interests of the receiver would not be to his personal interests, but to be to the company and to the shareholders. So whether he has competing interests or not, he can't justify his actions by doing things that benefit himself. So I don't understand what that's. By the way, first three paragraphs, I have no idea what they're responding to in my email. I'm just kind of reading them in the order they're providing. But even internally, I really don't understand what they're stating and what the purpose is. I don't think it's accurate either. And if it's accurate, then I think it creates a whole bunch of different issues. Continuing on, while a report to the court will be coming, when is it coming? It's been months. And again, it doesn't have to be a 50-page report. It could be a 2-page report. It doesn't have to be like 50 pages of bullshitting and wasting money. It could be a 2-page report, just brings up to date as to what's happened since the last report. Shouldn't take more than a quick little nothing. We don't have to piss away more money. You can keep people informed, or you can come on my live. You could do a live with the receiver. I think you did it originally. I don't know why you gone dark. You could post it on X. You could do all that stuff. None of that stuff costs a fortune, and there's no excuse for not keeping people informed. None. No excuse, because you don't have to do it in the format you did it before, with a 50-page or 45-page report that you drafted, and not because you told me you drafted it, not the receiver. You don't have to do it. Do a 2-page, brings up to speed. Doesn't have to, and it could be done tomorrow. So I'm expecting before the end of the week to get a 2-page report that brings up to speed. There's no reason not to. I kind of told you now what you need to do. So please do it, really. No excuse. Next. And I found this paragraph interesting, and listen really carefully. And then listen to my question, and then listen to the response, and see if any of this makes sense. I haven't seen what Forster posted. I'm not sure if I believe that, by the way. It was suggested that you may have, that's being me, have seen the actual term sheet. Can you confirm? Now, I don't know what term sheet he's referring to. As far as I can recall, I have not seen any term sheet. But since he doesn't define it, it's certainly ambiguous, but to the best of my knowledge, I haven't. Term sheet usually is when you're doing a transaction, you start off with a very general list of terms, and eventually that list of terms will turn into a final agreement. But it's basically an outline of a transaction, but not without any specifics. And it doesn't mean that a transaction will occur. But I haven't seen any term sheet, as far as I can remember. I haven't seen any term sheet. So I don't know why he thinks I did. And then he says, I think you're aware of the actual issue. I have no idea what he's talking about. So let me read this again. I haven't seen what Forster posted. It was suggested that you may have seen the actual term sheet. Can you confirm? If so, I think you're aware of the actual issue, and I have no idea what he's talking about. And again, this is kind of like mumbo jumbo. So this is the receiver's counsel being responsive, not responsive, replying to, but creating more ambiguity and less clarity, and not being clear. You could say, what term sheet? How about like describing a term sheet? I speak with his counsel, and certainly it's not our intent to argue and or negotiate by proxy. So he says, and I guess this is indirectly saying that they have been in contact with Forster's counsel. Doesn't say how often and when, but he's saying, if we're going to discuss this deal, I think I'm interpreting, if we're going to discuss this deal, I'm going to do it with Forster's counsel, not by some guy who's like a proxy of Forster. And I don't have any rights to negotiate on behalf of Forster, so maybe it's referring to somebody else. I don't know. Finally, as I told another investor, if there was concern regarding the audit, that would be something we disclose to the court. Like, doesn't say that there aren't concerns, but he says we would disclose it to the court. Like you, and I don't know why the amount of time that has gone by is not reason to raise concern. Like you, I personally wanted it done sooner, but that doesn't mean something is wrong. It just means things are more involved than anticipated. Again, complete. I mean, how is that supposed to provide any clarity to anything? Perhaps it's what I speculated. Perhaps the SEC has directed that the audit not be released so they can catch one of the other bad guys in a lie. Perhaps that's what it is, but it's completely impossible to ascertain what it is. And so this was the response to my email. Apparently, I don't think it added any clarity. I think it only added more ambiguity, and it certainly didn't address the questions I asked. Or if it did, I don't recognize them. So after I received that, and this is 24th, this is yesterday, this is up to date, I say, thanks for your response. No, I have not seen or been party to any term sheet. Let me read it again. Thanks for your response. No, I have not seen or been party to any term sheet as far as I know, so do not know what you are substantively referring to. If you could explain, that would be appreciated. Thanks. His response, so we're mine went out 342, he responded 346. Maybe I misunderstood something that was relayed to me. You might expect the term sheet we received was marked confidential. I'm hoping to get that lifted. And my response at 4:05 p.m. yesterday, perhaps I have limited amnesia, but I do not recall seeing a confidential term sheet regarding GTII, let alone any. But perhaps you are referring to something else, or that the source was an error. I look forward to seeing the completed audit. I would also be interested in the name of your source. Thanks. And his response, and originally it sounded like to me, and maybe you have a different take, but it sounded like to me he was accusing me of having seen some confidential term sheet, apparently with regard to GTII. And I kind of said, who told you that? And I not that I recall. And his final reply was, no, the part about it being confidential is that I cannot send the term sheet to you. I wasn't implying that you somehow received something inappropriately, just being careful. And I have no idea what he's talking about. If I didn't receive a term sheet, so he's saying, no, he wasn't implying that I received something, but he actually accused me of receiving something. And then he says, whatever. It doesn't make any sense to me. I didn't challenge him. I responded, okay, thanks. And that's my last communication with him through yesterday. So we know what Forster said. We've now seen, I guess, what the Receivers Council has said. I don't think it adds any clarity. And so, to anybody out there, you are entitled to act as you see fit. I am going to certainly file something when the time becomes appropriate, when there's a court proceeding. I certainly will. I'm certainly going to contest the reasonableness of the compensation to the receiver. And if you are in the same boat, you should do the same if you feel the same. If not, then you shouldn't. It's your choice. If you feel the receiver is entitled to whatever he's entitled to, then so be it. If you think that what the receiver is receiving is not reasonable compensation, then you have the right to oppose compensation as it comes out. And obviously the point was, in the beginning, we weren't involved in setting the compensation. The only shares that we thought were available to be undisputed were about 30 million, because 65 million shares were referenced. 35 were returned by, I think, Luke Rabari, and he arranged for the return. They weren't his shares, but he arranged for the return, left about 30 million. And if that would be 10% of that, it's 3 million shares. It's a lot different than 180 million shares. And is it reasonable to have the receiver as being the top shareholder, being control of the business? That doesn't make a lot of sense. But I think the receiver should receive compensation, but it should be appropriate for what he did. So the Receivers Council responded. Forster has responded. He seems like he's impatient and upset. I'm waiting for the further information about the claims process. There was a filing involving a claim by Bronx Eye Care, I think. Some deal apparently has been struck. They're documenting the deal. Then it will be submitted to the court. We'll have an opportunity to sound off on it. I believe that all claims were to be submitted. All claims regarding monetary claims were to be submitted by the 15th of September. The only ones they asked for an extension were the Bronx Eye Care, I think. So I don't think anybody else asked for extension. The 15th has passed. So I presume that all the claims are in. I expect there, because I think that's what they promised, is some type of summary of the claims would be prepared. And then the receiver is going to decide which ones to pay or not. And then the court will decide if that's the way it should go. In terms of the disputed shares, I think the disputed shareholders have about another 45 days or less to oppose the disputed characterization. And then after that, there'll be some procedure set up by the court to determine if they can keep them or not. And other than that, I have nothing else to add. I expect to see more stuff from the Receivers Council. And if you have anything to add, please let me know. If you yourself filed anything with the SEC, feel free to share it with me. Happy to see anything. And that's it. So thank you for hanging out. Thank you for being around. And by the way, Hawkeye, my nickname, and you can guess, by the way, my nickname, especially as a teen, was Bozo. So I take that as a positive. If you're calling the Gtii receiver a bozo, I think that's a compliment in my mind. So anyway, everybody out there, take care. I'll keep you apprised. Obviously, I promise I'll keep you apprised. We'll stay on the know, and I will report as we receive information. Everybody be well, take care, and have a great day, and see you soon. Really, that's all I got to say.